guys. Have a seat. Thank you.
The city's probably going to ask.
Okay, we have a busy
Right now, you have 3,000 bondable. Okay, but the city's going to ask for an increase.
morning, Mr. Loomis.
Good morning, Judge.
I know we have a busy morning. Are y'all ready?
We are set. Mr. Coughlin is reading over the police report and would like some more time to consider what he wants to do.
All right, we'll give him all the time he needs. We'll just trail that. We do have, I believe, 2 officers in here, and we're going to have a bail hearing, I'm assuming, on that case as well. So,
Mr. Coughlin?
Yes. So give Mr. Coughlin all the times he needs. In the meantime, if you would like any of the complaints read, let me know. Or in the absence of hearing a request, I would assume you're willing to waive the reading of the complaint. We'll stipulate to a factual basis on the entry of all no contest and guilty pleas.
We would do that, Judge.
Right.
We'd waive the reading of formal complaint, waive the reading of the complaints, and stipulate to a factual basis, pleas of no contest.
Okay, give me just a second. Okay, let's start off with City versus Zachary. Oh, strike that. We'll wait on that one. City versus Jesus Mancha, 12 CR 12431.
Mancha? Yeah.
Morning, Mr. Mancha.
Morning, sir.
Mr. Mancha, did you see the videotape today explaining your constitutional rights?
I did, sir.
Any question related to any of the information on the videotape?
Not at this time, sir.
All right, then, Mr. Loomis, a single count of possession of drug paraphernalia. What does Mr. Mancha intend to do?
Mr. Mancha is going to enter a plea of no contest.
Is that correct, Mr. Mancha? No contest?
Yes, sir.
All right, by entering a plea of no contest, you understand you're giving up the rights shown on the videotape, including your right to have a trial and a right to be represented by an attorney at that trial?
Yes, sir.
You understand I can give you up to 6 months in jail and up to $1,000 fine on this offense if I deem it appropriate?
Yes, sir.
Ms. Drake, anything?
Your Honor, this was a meth pipe, so I'm going to recommend 14 days.
Mr. Loomis?
Judge, Mr. Mancha is on SSI disability for medical issues, so he's not employed. We'd ask for not more than 3 days on it.
Mr. Mancha, anything you'd like to say?
No, sir. Thank you.
Five days, Washington County Jail, credit for time served. Thank you.
So you got 5 days.
Now, is
So I got time served.
No, you got 5 days. But credit
Ramos,
for
are
time
you here on the Davila matter?
Hi.
Okay, so she is here on that case. Okay, thank you. Let's go ahead and we have someone in the courtroom on City versus Kevin Davila, 12 CR 08208. And is this Mr. Davila's mother?
But they would have to.
Mr. Loomis, Mr. Davila's mother is present in court. Obviously, as you know, she can hear and see Mr. Davila, but Mr. Davila can not see her. So he's here. Mr. Davila, good morning.
Good morning, sir.
Did you see the videotape today explaining your rights?
Yes, sir.
And do you have any question? Well, you know what? Here's what we got going on. You were here on the 26th of June on the simple battery and the contempt of court with your attorney, Judge Dilworth. You pled guilty to the simple battery, made admission on the contempt of court. Judge Dilworth continued sentencing till today for an evaluation. So that's what we have today. We have an imposition on the simple battery and an imposition. And I have in front of me, you know what else we got going on? We also have a DUI case in 12 CR 12043. Where Mr. Davila pled guilty same day, June 26. He was a 202. So that's why we evaluated him. So we have...
Just by being there, then
with all the anxieties I suffer from about, earning my living, though now I have overcome them because I've been around for like 6 years, and I would be more than happy to assist them in any way that they
Right.
request.
Is there any reason you didn't come to court?
Or insist.
I know I know you're homeless, you're not employed, but is there a reason you didn't come to court?
Well, sir, someone's been all through the country, informing the police that I'm trespassing here, trespassing there, and it just occurred to me that I'm not trespassing, I'm not intending to do anything, and with all that building up, that's someone trying to say that I'm going somewhere intending to do some wrong, and I am just plain are not.
All right, here's what I'm going to do. You got a remote but substantial criminal history, but this case is very unaggravated. You've been in jail a couple days. Time served on both the trespassing and the contempt. That gets you out of court, out of the jail. Thank you.
Okay, you're done. Mr. Coughlin is ready anytime the court is, Judge.
All right, we're ready. Let's see. City versus Zachary Barker Coughlin, 12 CR 12420. And present court are officers BYE. All the young guys I don't recognize anymore. Morning, Mr. Coughlin. How are you?
Thank you.
Go ahead and try again.
Can you hear me, Mr. Coughlin?
I'm fine, Your Honor. Thank you.
All right. Did you see the videotape today explaining your constitutional rights?
Yes, sir, Your Honor, I did.
And do you have any question, Mr. Coughlin, about those rights?
No, sir.
All right. We're here on 2 charges, one of disturbing the peace, 3 charges, one of disturbing the peace, one of no insurance as required by law, and the 3rd charge is failure to properly secure a load.
Judge, may I have one moment with Mr.
Yeah.
Coughlin?
You guys both involved in the arrest here? I know I see you signing complaints.
We're ready, Judge.
All right, Mr. Coughlin, to the charge of disturbing the peace, what is your plea?
Yes, sir, Your Honor, not guilty.
All right, same to the insurance and the failure to have the load properly secured.
Yes, sir.
All right, I'll enter not guilty pleas on all 3 of these. Now, what I'm going to do, Mr. Coughlin, we're starting from square one on this criminal case, okay? I don't know where this case will be assigned, but I am going to appoint an attorney to represent you on the case. You are certainly free at any time, and I know we've spent a lot of time going over this in the past. We've had lots of hearings, you and I. You're free to represent yourself. You're free to hire a lawyer to represent you. But I'm going to start off by giving you the appointment of a legal defender right now. It won't be Mr. Puentes. Mr. Loomis, do you have any input? I don't want to back you into any kind of corner either. Ms. McKenna is retiring, as you know. We don't know when that case is going to be staffed.
And I think that Mr. Coughlin has a conflict with Mr. Tatel in light of the fact that Mr. Tatel works at Washington Legal Services,
Okay,
where
so it won't be
Mr.
Tatel.
Coughlin used to work.
So why don't we do this? Mr. Coughlin, I'm going to start off by appointing Mr. Loomis to represent you. But you will either be and Mr. Loomis is an excellent attorney. I know we went through this before and you wanted to represent yourself, and you did a pretty good job yourself. But we may revisit that and appoint another lawyer to represent you if we have another lawyer on board to give you kind of a fresh contact. Do you understand that?
Yes, sir.
So I don't want you to think that because I've appointed Mr. Loomis today, that I may not appoint another lawyer depending on the trial date. Now, anything further from either counsel?
Your Honor, City would like to make a motion regarding bail.
Okay, the city, go ahead, Ms. Drake.
Your Honor, present in the courtroom today are Officers Weaver and Officer Dye. They were the arresting officers on this case. They're present today. They wanted to impress upon the court and upon myself that Mr. Coughlin's been a constant problem for them. They've been going out to his location multiple times, and I am going to ask them to give more details to the court regarding that in order to support my bail motion. I do think that if he gets out of custody, his conduct is likely to continue. I'd like to see bail set at $1,000 cash only on each count.
Mr. Loomis, we'll get back to the, I'm going to hear from Mr. Loomis. I'm going to give the officers a chance to address the court and then give Mr. Loomis a chance to respond based on those comments. Go ahead, Mr. Loomis.
Well, Judge, I know we're all very familiar with Mr. Coughlin at this point. He does do well when he's taking his medications, and today here in the jail he's doing well. He's responding well. He's understanding things. Obviously, he's got a history in the community, which I would characterize as kind of minor problems that turn into mountains as a result of how Mr. Coughlin's been dealing with them. But when he's on his medications, he does well, and perhaps. And Judge, as you're aware, Mr. Coughlin went to high school here. His family is here. He can live with his mother at her house. He can, is what I'm told. And so what I would suggest, Judge, or what I'm going to request is that you grant him an OR release, but that it be conditioned upon him taking his medications as required by his doctor.
That, of course, is very hard to, that's a very reasonable request, nonetheless a very difficult order to enforce. Ms. Drake, do the officers want to present any information to the court? Okay, do we need to have them sworn, Mr. Loomis? This is a bail hearing.
Let's have them sworn, Judge.
Let's have officers, how many are going to be making any statements? Okay, why don't you raise your right hand. Do you swear or affirm under penalty of perjury that you will testify truthfully and accurately this morning regarding all matters related to this case? Okay, why don't you come up to the microphone? That way Mr. Coughlin and Mr. Loomis can hear you. And this is Officer Dye. State your name, and Mr. Officer Dye, what we're here today is to consider what factors the court should take into account related to in support of the city's motion for a bail increase. Thank you. Go ahead.
Brian Dye, DYE. I just wanted the court to know that I researched the 1680 Sky Mountain address, and according to our dispatch records, we've been out there approximately 10 times dealing with Mr. Coughlin in the last month or so.
Thank you. Did you hear that, Mr. Loomis?
10 times the 1680?
Yes. Okay. I told you I'd give you the final word. Mr. Loomis, go ahead. Previous contacts, is that correct? I want to make sure I heard that too. Sorry, Officer Dye.
Not every time resulted in direct contact. Sometimes management would call stating he had locked himself in the shed. We were unable to make contact.
10 calls for service?
Correct. Police responded there 10 times, whether or not we made contact with Mr. Coughlin.
Thank you. Okay, Mr. Loomis? Anything further?
If I can make a statement, sir, please.
All right, Mr. Call. Here's what I'm going to do. Under 178-4853, our bail statute, I'm not concerned so much, Mr. Coughlin, with your criminal history. I'd consider it modest and unaggravated. So I'm not going to make any, although you do have a history, it's very modest, and I understand that. You do have substantial ties to the community. I know you went to the Reno High here. I know your parents are in town. My real concern now, and this is shared by the other judges, is the threat of harm to yourself and others. And I'm starting, Mr. Coughlin, to be concerned about your well-being. I mean, for the first time, really worried about you putting yourself in a position where some kind of serious harm comes to you as a result of your conduct when you're maybe not on your meds or certainly off your meds. And that's a real factor that the court takes into consideration. So here's what I'm going to do. I'm setting bail on each count at $1,000 cash. I'm going to order a psych eval, and the reason I'm ordering a psych eval, I know you were evaluated in the district court within the last 2 months and have determined to be competent, but I never had access to that, and I'm not privy to that evaluation. And this court, to do any kind of meaningful job, needs more information to at least, at the minimum, take all efforts we can do to make sure that your safety and safety of other citizens in the community is not jeopardized. And that's an obligation the court is going to follow up on. I know you don't want to be there, but this is I think you're getting to be a point where you're putting yourself in a real position of being harmed either by citizens of the community, by yourself, or by the police. 1,000
Your Honor,
cash.
can I say something, please?
Yes, you can.
Yes, sir. I'd just like to say that I have no intention of going anywhere near that Sky Mountain. I've gotten the message from the police department. It was my understanding that if I had a valid lease there, which I still do, that it wouldn't be trespassing to remove my items. I was given a 5-day unlawful detainer notice recently. I believe my position is that this charges, the disturbing the peace, is full of lies, and that this apartment complex has continually lied because they don't wish to go through the civil eviction process. It's too long and hard for them, so they're seeking to leverage the police department. Your Honor, I take my medication religiously. It's not a case of I don't want to take it. I'm not a harm to the community, but, sir, I can tell you, I'm wising up here, sir, and I'm not going to try to assert my rights. I'm not going to say, oh, you can't arrest me for trespass if I have a valid lease. I'm not going to say any of that, sir. I just want to get the hell out of there and move on with my life.
I understand.
So please just let me out, sir. I'm not a danger to anybody. I've gotten the message, and I have responsibilities that I really, really need to take care of, sir, and I can't do it when I'm in jail. Please just let me out.
I will revisit this issue after I see the psych evaluation. I'm not doing anything because I do have legitimate concerns about you, Mr. Coughlin, and I'm doing.
Can I give you the old one, sir?
I'm doing this in your best interest, as hard as it may seem at this time for you. That's what I'm doing. I want a new, fresh psych eval ordered. We have to write the order into that. We're going to expedite that, Mr. Coughlin. I'm going to see if we can get that done ASAP. I'm going to bring you back into videos. In the meantime, 1,000 cash only. That's the court's order. I'll be seeing you again. Gentlemen, thank you for coming in.
1,000 on each count.
1,000 cash only on each count, total of 3,000 cash.
Judge, Mr. Coughlin is prepared to release the mental health evaluation that was done back in May of this year, if that would satisfy the court's interest in the case.
I would like that one, and I'm going to order a new one. I'd like to both. If that's fine, I'll take a look at it, but I'm ordering a fresh, brand new one. Today is July 5th. I'm ordering a new one. We're going to go to the expense of paying for it. I'm going to get one.
Judge, if I might.
Go ahead.
In October, he had a mental health evaluation which found him to be competent. That was not done by a psychiatrist. In May, he has the mental health evaluation done by a psychiatrist through district court. Again, he's found competent. And he's responsive today.
Let me do this. Let's take a look at that one. If you can get me a copy of that one, Mr. Loomis, let's do this. Let's hold off on ordering another. And I understand that was actually done in the district court, stemming from the justice court charges, and it was not done by a psychiatric social worker. It was done by 2 psychiatrists, or a psychiatrist and a psychologist. And I think that's important. That's the kind of information I'm looking. So, Mr. Coughlin, I will use that one and take a look at it, and we will rediscuss bail. I don't want to say predispose myself to either way. I need to look at that. And before I make any further decisions, for the time being, bail is set at $3,000 cash total. Psych eval ordered, or court will consider the May 2012 district court evaluation. I can't imagine much has changed in the last 2 months, so that's what I'm going to do. That's the consideration
Your Honor,
I'm going to give you. Go ahead.
Just quickly, if I could say,
I'll give you the final word.
a lot has changed in the past 2 months, Your Honor. After Judge Elliott released me without any bail, April 27th, I got back on my Wellbutrin and my Adderall. I've lost probably, I want to say 25 to 30 pounds. I've worked out every day. I'm in very good shape. I've got a much better relationship going with my mother. I've addressed all the issues the Supreme Court of Nevada has asked me to with respect to winding up my practice. And the nurse here at the jail remarked that she could tell I was doing a lot better. And all of these arrests right here are incident to trying to store my possessions and then a lease disagreement. I'm not a danger to anyone, sir. I realize I need to just stay the heck away from the Reno Police Department. I have respect for them, but there's some issues when you have legal training where you think you have rights, but you should just let it go, and I understand that now.
And let me tell you, I've seen you for the past year, and I agree, you look much better, you look healthy. When you're on your meds, you're extremely high functioning, very articulate, you're very bright, everybody agrees with that. And I believe the police are here so that nothing happens to you. I believe that's how I see this. So anyway, I'll take a look at the evaluation. We will reconsider bail after I review it. That'll probably be sometime early next week. In the meantime, $3,000 cash total. Thank you. All right, gentlemen. Thank you. Thank you for coming in. I appreciate it. City versus Christopher Chris Campa. Mr. Loomis, if you need a minute or two, let me know.
Dave?
I did it.
All right, Mr. Campa, good morning.
Good morning.
Did you see the videotape explaining your rights this morning?
Yes.
Any questions?
No.
All right, we're here on 2 contempt of court warrants. One is fair to pay fines and fees totaling $720. One, there's an allegation going back to 2008 that you failed on a DUI case to report for your community service, your DUI level 1 school, and your victim impact panel. And I also, Mr. Loomis, and Ms. Drake, Mr. Camp is on a 30-day suspended sentence on his DUI stemming back to September 4th, 2008 from Pro Tem Judge Springate.
May I have a moment, Judge?
Yeah. Have full surgery on his Achilles. What's his number? I think I waited too long. The surgeon said I waited too long. They can't fix it. Additional, I have to have some backdoor surgery, taking stuff off my foot and attaching it. So this is probably a mess. It's serious. It's a mess. I'm going to call Randy on the phone. What? This is what it is. This happens when you try to self-diagnose.